2016-395, State of Arkansas versus Andrew Cunningham. Mr. Cunningham, have you made any arrangements to be represented by an attorney at this point?
Yeah, yesterday. Talked to Mark Hoover.
Have you made application to the Public Defender's Office?
Yeah, I turned it in yesterday.
Your Honor, we don't have it yet. I did. Mr. Cunningham is right. I did visit with him at the jail yesterday.
So you are applying to the Public Defender's Office.
Yes, sir.
I'll note that on the record. On the charges against you, which are possession of a controlled substance with the purpose to deliver methamphetamine, Class B felony, use or possession with intent to use drug paraphernalia to distribute methamphetamine, a separate Class B felony, and use or possession with the intent to use drug paraphernalia, Class D felony. On those charges, how do you now plead?
Your Honor, he, even though we've not been formally appointed, I would enter a plea on his behalf at this point of not guilty to all charges.
This matter is on the Division III docket of Judge Putman. I'm putting him down for is Judge Putman going to be here a week from today? That'd be the 15th. I'll put him down to reappear in front of Judge Putman on December 15th. All right. You may be excused, sir.
Your Honor,
Just a second.
he had talked to me about bond. Until we're formally appointed and the court can review the application, then if we are appointed, that is something, Andrew, that can be brought up before Judge Putman next week if we are appointed. All right?
All right. That's what the court's going to direct, is that I'll leave that matter for Judge Putman. There's a bond set at $30,000 at this point. I'll leave it set at that level, subject to review by Judge Putman at when he appears before Judge Putman. All right, you may be excused. 2015-272, 2015-348, State of Arkansas versus Edward Vanscoy.
Your Honor,
This is a reappearance on these matters. Let's see.
There has been an evaluation performed on Mr. Vanscoy that has been come back and it should be in the file, Your Honor.
that is correct, Your Honor.
Yes. I'm going to direct, I have a copy of it, I'm directing that this will be filed under seal in the case file, and a copy should be placed in both case files. Let's see, where we are on this is, I don't believe these matters, because of the evaluation, I think we're, let's see, when was the, petition wasn't filed until April of 2016, after the case was essentially 7 months old. So there's a substantial time that's going on. I'm putting it down for a pretrial on January 26th in both of these cases, setting it for trial on the session of court for February 27th at this time. Is there any objection from the state to the based on the forensic examination, any request to continue the issue? Is there a hearing requested on the evaluation?
No, Your Honor.
Not on behalf of the state, Your Honor.
Right. Court's directing that the evaluation report will be placed in the court file and filed in the court file under seal. The case is now set for pretrial on January 26th of 2017 and trial during the week of February 27th. You may be excused, sir.
Your Honor, before he is excused, I'd like to at least approach the issue of bond on Mr. Vanscoy. With the pending evaluation, of course, we were not able to request any lowering of his bond. Mr. Vanscoy has been in jail for 70 days as of today. He has a residence, a 261 West 2nd in Mountain Home that he can go and live with a Dakota Zastro. Your Honor, we would ask that his bond, at this point, since the evaluation has come back, we would ask that his bond be lowered to $10,000.
Your Honor, the state would object in this case if the court notes the type of cases we're looking at here. These were instances that have not only happened once, they continue to happen. It's like a broken record about that, but it has happened. We also believe there are another case yet pending. We have concern that Mr. Vanscoy does not understand his actions and will continue to reoffend. And this is a particular matter where I don't know who this person is going to live with is, but the state again has great concern. I know law enforcement has great concern about Mr. Vanscoy being back out and allowed to continue to commit these crimes again in the future, Your Honor.
Your Honor, I don't think concern that or suspicion that he might re-violate is enough to deny a reasonable bond to Mr. Vanscoy. And given that he has an address he can go to, and we'd ask that he be bonded out at $10,000.
Court, looking through the file, unless there's something that, I haven't had a chance to read through the whole file and determine if there are any previous reductions, but the way I understand, from what I've read in the file, he has one case in which the bond was set at $25,000 originally, and the other case in which it was the bond was set at $10,000, making a total bond of $35,000 between the two cases. The court has now that the evaluation is complete, the court has every reason to think, to be concerned, both about Mr. Vanscoy as a flight risk, and also Mr. Vanscoy as a reoffending risk, given the nature of the crimes, which this type of behavior is not normal, and it does. I think there is significant scientific evidence to indicate that it has a certain repetitive effect in many cases. On that basis, the court is concerned on those issues, and for that reason, the court is going to leave the bond where they are for a total bond of $35,000. If he does make bond, the court would condition the bond on him wearing an ankle monitor, so his whereabouts can be monitored. That's going to be the order of the court.
Your Honor, the court may or may not remember in this case, previously Mr. Vanscoy had an ankle monitor. One reason he was picked back up is he failed to comply with the terms and conditions of that ankle monitor.
That's where I'm leaving it, though.
Thank you, Your Honor.
All right.